I'm good, thank you.
Okay, so my Supreme Court case is Webster versus Reproductive Health Services. So it's like similar to the Roe v. Wade case, but it was ruled constitutional, so it's a little different. Okay, so background information. In 1986, Missouri passed these 7 statutes that were, in many of the people's eyes, unconstitutional regarding abortion. It had set mandates that were favoring the child, like almost as a pro-life choice, and then there was a federal ruling filed by healthcare professionals to fight this, but it ended up going to a federal court where it was ruled unconstitutional, and then Webster, the Missouri Attorney General, appealed it. These are the Supreme Court justices, as you can see, like some memorable faces like Thurgood Marshall, and so these 3 had a different idea, and they wrote a different opinion, and then coming up on the next slide, it'll be talking about it. So this is William Rehnquist, in the middle is Anthony Kelly, and on the right is Byron White, and they wrote the plurality opinion, which kind of contradicts what most cases have been about. And it's a 3-part process. So the first part, so life of each human being begins at conception, and all unborn children have protectable interest in life, health, and well-being. The main thing with this is plaintiff's challenge where life really began, so whether it was different parts of the womb and stuff. So second aspect, prohibited abortions in public hospitals, even though it was a public right to consult help, and then that's what the plaintiff challenged, and it was also again ruled constitutional. And then the third one was required physicians to perform unnecessary medical tests, which would be in the 2nd to 3rd trimester, regarding Roe v. Wade, which didn't even need to happen, and then see it violated the 3rd trimester framework. So then this case relates to Roe v. Wade, and Roe v. Wade, because the Supreme Court ruled that states have no legitimate interest in regulating abortion during the 1st trimester, so it's up to the woman. The 2nd trimester may pass abortion. The main idea is women's health, to help the mother. And it went dark again.
Sorry.
That's okay. Do you want me to stop it because I'm 3 slides ahead?
Yeah, sorry.
That's okay.
How about you just read from your
Okay.
other? Oh. Okay, just read from that unless I get it.
Okay. So it's similar to Roe v. Wade relating to the 2nd trimester because it focuses on women's health. And then the 3rd trimester may ban abortion altogether because it's within a certain week range.
Sorry, it's tripping out.
Within a certain week range to where it's not healthy for either the baby or the mother. Other justices include Sandra Day O'Connor and Tony Smith. They wrote separate concurring opinions regarding this. So they wrote separate concurring opinions, ruling that this idea was unconstitutional. And then Harry Blackman and John Paul Stevens, again, wrote separate positions regarding it. And then Thurgood Marshall, one of the power players, joined Blackman's idea. So then the Webster case, Supreme Court acknowledged the statute and that it clashed with the Roe trimester idea, which was somewhat falsified because over time it's progressed to the point where that 3rd trimester thing isn't necessary. And then the Webster case, again, the trimester formula created by Roe, the court pointed out had major flaws. So if the child was viable, which means like alive, within the ready to be born within the 25 weeks of pregnancy, then it was okay. And then the court held that Missouri statute requiring viable examinations during the 2nd trimester was reasonably related to this important government interest, and then the courts emphasized that its holding of Webster would leave distributed. The ruling was very close. It was 5 to 4 towards Webster, so it was ruled constitutional. The 2 amendments that relate to this are the 5th and 14th. And the court reiterated that women still have the legal right to abortion, but it doesn't make sense because so many laws were banished when women were trying to get an abortion. This is the Fifth Amendment. Federal government not deprive individuals of life, liberty, and property with due process of the law. And this is the 14th. Equal protection limits the state and federal governments' power to discriminate in their employees' practices by treating employees unequally. This regards to doctors, because they were banned from so many new things and they had a test in the second trimester. And then Justice Salia expressed regret that the court had not taken this opportunity to completely overrule Roe. So it wasn't changed. That's what many people were hoping for, to go back to the Roe v. Wade case and rule differently on it. And then the author of the Roe opinion, Blackman, agreed with the court's decision and used the idea of the plurality opinion, and it conceded with the court's holding in Webster and would enable the states to regulate abortion earlier in pregnancy. And these are my citations.
Okay.